Welcome everybody to Law&Crime Daily. I'm Jesse Weber. An Iowa man released early from prison is locked back up again. He's accused of kidnapping a little girl and killing her. The prosecution gave its opening statement on Thursday in the case of Henry Dinkins. Now, we want to make the connection between the defendant and the alleged victim clear here. So Dinkins is not her father. Rather, he's the father of her half-brother. Breasia Terrell and her brother were staying with Dinkins and his girlfriend overnight in Davenport, Iowa in 2020. At some point during the night, it's believed that Dinkins took Breasia from the apartment and killed her. Her disappearance prompted a massive search, but her remains weren't found until nearly a year after she was reported missing. Fishermen spotted her body in a pond about 25 miles away from Davenport in March of 2021. At the time, Dinkins was locked up on an unrelated charge. See, it turns out he's a sex offender who had been released early from prison but was required to register, and police say he didn't do that, so they arrested him. Then, when Breasia's remains were found, they charged him with kidnapping and murder. The prosecutor laid out what Dinkins' girlfriend says happened that very night.
He happens to pull back the curtain to the window and looks out, and little Breasia is standing by a maroon Chevy Impala on the passenger side of the vehicle. Mr. Dinkins returns to the apartment. He comes up. He's very, very frazzled. Ms. Culberson wants to know what's going on. He said, "There's issues. I'll talk with you about it later." Where's Breasia? There's no Breasia. And then she goes down to the maroon Chevy Impala. Breasia is not in the car. When the three gentlemen went to go fishing, they were walking down that steep incline, having parked their pickup trucks up on the road. And because we're talking about March 22nd, there's no vegetation. One of the gentlemen looks over to what would be his right as he's walking down, looks to the north essentially, and he sees a human skull. He points it out to his two friends. They go over and check, and sure enough, it is a human skull. Because Breasia Terrell and her having been missing was so highly publicized, the gentleman will testify that at some point they made the connection. Is this Breasia Terrell's remains?
Okay, let's break this down. I'm joined right now by my co-host, defense attorney Brian Buckmeyer. Brian, good to see you. I want to start with the sex offender part. Is that going to be playing a role in this trial? Because on one hand, it's not connected, but on the other hand, he shouldn't have been around minors and was supposed to register and didn't. Is it going to play a role in the case at all?
I go back and forth with that because I do think, especially when the prosecution is talking about maybe consciousness of guilt, when he comes back to the home without the daughter and he just kind of freaks out, as the way they put it. But we're talking about a sexual conviction from 1990 when he was 17. Mm-hmm. Now he's 51. So there's two issues. One, are the crimes truly connected? The sexual assault or the registration and this. Two, it's over 30 years ago. How are you going to use what he did then to try to show some sort of innocence or guilt here now?
But again, this is a crime against a minor. Should the jury not know about that?
Is it a sexual crime?
Well, that's a good point. That's a good point. I guess the question is, how important is it for the prosecution to put that in there? You heard the opening statement. Do you think that they have enough in this case without presenting anything about his past?
I think they've got it. And I think that's where the judge will push back and they would say, why do you need this? If you've got the circumstantial evidence of him leaving with the daughter, him coming back without her, what does the registration have to do with any of this? And I think that's where the prosecution will struggle. The other thing too is, once you say he's a sex offender and he should have registered and he's not supposed to be around minors, my fear, and I think the defense's fear and the judge's fear is the jury closes their ears and they say, forget about it. And that's where you get into the land of too prejudicial and not probative enough.
So you talked about that you think they have enough. What do you think they have enough? Just the idea of he was the last one with her? Because her body wasn't found like the next day. It was found, about a year later. What's the strongest evidence do you think against him?
It's not necessarily one piece of evidence that is strong. This is, I think, a really good test case for reasonable doubt. Because they don't have direct evidence, but all the evidence around it doesn't have a reasonable explanation for him not killing her. And I think that's the defense's real struggle here. Find a reasonable explanation for him not being the one, and maybe they have a case, but right now I don't see it.
It's a disturbing case, to say the least. And, it's interesting we talked about the sex offender because we were having a conversation this morning, and some of the people we were talking to said if I was on the jury and I knew that about him, they would probably convict him on that alone. And Welcome back to Law&Crime Daily, everybody. So we're continuing our coverage of the start of Henry Dinkins' kidnapping and murder trial. The case is a little bit unique because the defendant chose to have a bench trial instead of a jury trial. So Dinkins is accused of taking a 10-year-old girl, the daughter of the mother of one of his children, while she was sleeping over at his apartment. Breasia Terrell was last seen alive in Davenport, Iowa in July 2020, and her skeletal remains were found the next March by some fishermen. Dinkins was a sex offender who was in police custody when Breasia's body was found for failing to register. Dinkins chose to have a bench trial. Now that means that a judge is going to decide his guilt or innocence, and there's no jury. When the prosecution wrapped up its opening statement on Thursday, the defense decided to hold off on their opening a little bit longer.
And that's all for the statement.
Thank you, Ms. Cunningham. Mr. Freese, is the defense going to present an opening statement?
Your Honor, the defense is going to reserve its right to make an opening statement and close the government's evidence.
All right. Thank you very much. That'll conclude the proceedings this morning.
I'm surprised by this, Brian. Why he chose to have a judge over a jury. Usually my understanding is you choose a bench trial when there's like a complicated issue of law. You think maybe the judge will be better, suited to handle that than a jury. Why do that here?
So there are two reasons why a person would have a bench trial rather than jury trial, and you do have the right to a jury, so oftentimes you can choose. The first one, which I don't think it is when you get that wink and the nod from the judge, and I've had that before. When you're making arguments as a defense attorney, judge just doesn't work, yada 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 yada, and the judge says, "Don't worry about it. Don't." And when you get that, the judge is going to take care of it because they understand, and then probably on your side when they're not saying it. But that's not the issue here. I think when you have such a gruesome case, and there's a potential where you might have the fact that your client's a registered sex offender come out, you really want to focus not on the emotional and the disgusting aspects of it. You want to focus on a very key legal issue that you're hoping the judge will focus on and ignore the rest, as opposed to a jury who would take it all in.
That's a good point. And also I should tell you that we know that this was moved, right? It's moved from Scott County to Lynn County, and then back once it was a bench trial. How does that affect anything?
So it moved from Scott County because of the high publicity. And I think that's where they were like, I don't want to do a jury trial here.
Right.
And then went to Lynn County and they said, hey, even if we go to Lynn County, maybe they polled the jury. Maybe they kind of looked around and did focus groups and said, we're still not good here. And so I think they might have done a little bit of forum shopping or judge shopping and said, if we go back and have a bench trial, we don't have to worry about a jury pool in Scott or Lynn County. We can go back to the judge we had before who's heard all these horrible issues for months and months on end and might not be reacting to it as if someone who had heard it for the first time. And I think that's a bit of the strategy here.
And speaking about the defense's strategy, the fact that they chose to reserve an opening statement, the history that I've seen that is mostly, let's see what the prosecution's case is, right? We don't have to jump the gun on what we want to say.
Yeah, a defense attorney doesn't have to give an opening statement, and they can do like they did here and reserve it till afterwards. It also gives you kind of like two bites of the apple of a summation, because you get to give your opening after the prosecution's case, and then you get a closing afterwards. And so you can kind of, like you said, see what they've got, poke holes in your opening after their case, and then do it again after maybe you present a case or in your closing.
And I have to imagine that's more beneficial in front of a judge who's seen that happen before than a jury who might be like, wasn't the defense supposed to go right here? And they might, make something of it. That's maybe also a consideration as well.